You were right. We were right. They can't gaslight us anymore. It's official. What Daniel Andrews did to Victorians during COVID were human rights abuses. You were right. Send this to the other people that were also right, because we and they were right when it mattered, right at the time, right when it would have made a difference if only more people had listened. I documented the human rights abuses of the Victorian lockdown era in my documentary Battleground Melbourne. I'll play some of it up here for you so that you can preview it. If you haven't yet seen it, then I suggest you watch it at battlegroundmelbourne.com or via the YouTube link that I'll put in the description. It is a full-length documentary. It's won 14 awards around the world. I promise you it is a good watch, but it's a hard watch also for those of us that lived through it. But today, the Human Rights Commission of Australia has finally agreed with what I said at the time and what I said in that documentary. And they've said it 5 years too late to make a difference, but they finally agree. We were right. And now they're right too, but they're right too late. When I heard the news today that they'd said this finally, I actually got quite angry because it just brought back so much of the trauma. Yes, there was the violence that the protesters like me endured at the hands of Victoria Police, but there's also so much more than that. There's the violation of being told that you're not essential, of being placed under house arrest, accused of carrying a virus that sometimes wasn't even in the country while we were locked in our homes. The violation of watching our children suffer indoors with concrete bollards and sand and council tape blocking off playgrounds. The violation of being denied medical care because you didn't agree to be experimented on. The violation of having loved ones pass away without those final conversations because, we can't have them risking getting COVID in their dying days. The indignity of having police raiding weddings and funerals to count heads and check vaccine passports. The Ring of Steel, 5 kilometre radius, 8 p.m. curfew, 4 reasons to leave home. The list goes on and on. Police were arresting people for sitting on park benches, for watching sunsets, for taking their bins out after 8 p.m. It was madness. And you were right. We were right. They were violating human rights. They can't gaslight us anymore because we were right. We have survived the largest brainwashing campaign in history with literally billions of dollars worth of propaganda coming at us from every direction, backed by threats of violence from police and social sanction and rejection from family and friends, and we survived. We stood our ground, and we were right. And we're not being right in hindsight like what the Human Rights Commission are. We were right at the time. I'm going to play you part of an interview that I did with then Victorian MP Tim Quilty in September 2020, where I called it. I called the human rights violations at the time, and I went into detail regarding the Victorian Charter of Human Rights and Responsibilities to explain exactly why they were violating our rights. Have a listen.
Do you think that the protest on Saturday is actually illegal?
No, I don't. There's two common misconceptions with how people read the interaction between the emergency declaration and Victorian human rights law, and I want to dispel both of them right from the outset. Some people think because there's an emergency declaration that overrides everything else, that whatever the emergency declaration says goes. And I have relatives who are in the police force and friends who are in the police force, and that tends to be how they default. When you challenge the legality of things, they say, oh, but I've read the legislation, I read the emergency declaration, it gives me the power to do all of these things. And they assume that therefore means that no other law applies anymore. At the other end of the spectrum, you've got some people who don't know the law necessarily very well, but they're very passionate about their rights. And they say, well, we have the Charter of Human Rights and Responsibilities in Victoria, and that says this, this, and this. It says I can freely assemble. It says I can go about my business, and that therefore overrides everything else. Well, I'm sorry, you're both wrong. Now, let me be clear here. The rights should trump everything else. I'm of the opinion that our rights are inalienable and that there are no circumstances under which a government ought to have the power to take them away. But unfortunately, that's not the reality in Victorian law right now. In Victorian law, the Human Rights Charter. So if I can quote from humanrights.vic.gov.au under section 7.2 of the Charter, it says this: rights may be limited in certain circumstances, but it must be reasonable, necessary, justified, and proportionate. Now, that's not the actual legislation itself. That's the government's human rights website describing the legislation. But these are the words that it uses. The limitation on our rights must be reasonable, necessary, justified, and proportionate. And it has to be all four of those things. If it fails on any one of those, it is no longer law, and the human rights law actually stands unreduced, unaffected by whatever law has been written. I want to add to that, reading from the legislation itself, under the Human Rights Charter 7.2.e, any reduction in these rights must take into account, quote, any less restrictive means reasonably available to achieve the purpose that the limitation seeks to achieve. So now there are 5 thresholds that any reduction to our human rights under the Victorian Human Rights Charter of Human Rights and Responsibilities, there are 5 thresholds that must be met before that stands. It must be reasonable, necessary, justified, proportionate, and the minimum level of restriction necessary to achieve whatever it is that that limitation was intended to achieve. The government do not believe that they have successfully achieved this. The government have no faith in the lawfulness of their own emergency declaration. I can demonstrate that because they have not allowed any fines that have been challenged to go to court. Now, this has been confirmed by Rebecca Falkingham from the Department of Justice and Community Safety, and she admits that no fines have been allowed to get to court. She says, quote, the fact are, most are resolved when they go to the review stage, end quote. Now, by resolved, she means withdrawn, and by most, she means every single one of them so far. Now, this isn't just me saying that the Human Rights Charter actually still applies. This is actually directly from the Victorian Attorney General, Jill Hennessy, when she was questioned by David Lindbergh, MLC, your colleague, Tim, and a member for the Liberal Democrats. And both of you have been doing wonderful work. When Jill Hennessy was questioned by him, she said, and I quote, what remains is the ability for people to be able to enforce and argue those rights. She's talking about the rights in the Charter. None of those rights have been suspended in terms of people's capability to go and enforce those in a court of law. So we know that they are still in force. We know that we can still argue them in a court of law. And the Human Rights Charter is very clear about the circumstances under which they can be limited. And I don't believe, and I don't think the government believes, that they have met those limits. He has also thrown the police under the bus. And if there's any police officers listening, I want you to log this in the back of your brain. The Premier does not have your back. You are carrying out his orders. You're being his foot soldiers. You're doing things that are incredibly unpopular, that are damaging the standing and the reputation of your uniform and the police force that I'm sure you love and you care for, and you want that reputation to be protected going forward. That reputation is being destroyed by the instructions and the orders that are coming down from the top right now from Daniel Andrews. But when the shoe is on the other foot and you need him to fight for you, he runs away like a little girl. He backed off so quickly and claimed that he had never given instruction that people should be arrested on the basis of their Facebook posts. He said that this morning. Now, he's throwing police officers under the bus. He's showing absolutely no loyalty. He's loyal only to himself. He has come in, and I don't believe he even thinks that his own laws are lawful, and I'll talk about that in a second. But he's come in drunk on power, done all kinds of things that I think he knows are just going way too far. He has manipulated the police officers, and he has a very subservient senior police set. The senior police should be absolutely ashamed of how supine they have been and how obedient they have been to what really are very obviously not lawful instructions that they've been given. And yet Daniel Andrews is not repaying the favour. He is not returning the loyalty. He will throw Victoria Police, and has proven that he will throw Victoria Police under the bus the moment the pressure is on. So I would question, if you're a Victoria Police officer, why are you going along with this? If you care about the Victoria Police and their reputation, why are you going along with this? Now, there's a couple of points I really want to make about the arrests in particular. It comes directly from the Honourable Murray Gleeson, ACQC, who's a former Chief Justice of the High Court of Australia. He was 10 years in the job from 1998 to 2008. And I want to take a fairly large quote from him because I don't want to be accused of misrepresenting what he has said. But he's talking about how important it is to not abuse the power of arrest. If you have the option of issuing a summons or doing something that is less invasive, less violating than arresting somebody, that you have a responsibility to do that instead. So here's the quote. The power of arrest is a power that is given for the purpose of taking into custody suspected wrongdoers in circumstances where such custody is necessary for the proper administration of justice. It is not a power that is to be exercised punitively. The police are not given a power to arrest suspected offenders for the purpose of enabling the police to punish such people, and the exercise of a power of arrest for such a purpose would be a serious abuse of power. That comes directly from the Honourable Murray Gleeson, and I want to continue with a second quote from him. Many criminal proceedings are of a kind that can be commenced either by arrest or by the much less dramatic procedure of the issue of a summons. Where there is no reasonable apprehension that an accused person will fail to turn up to court to answer the charges, excuse me, and where the issue of a summons is an available procedure, it would be quite wrong to use the procedure of arrest or warrant, where the purpose of doing so is to display the law operating with its full severity. I'm going to reread those last two sentences. It would be quite wrong to use the procedure of arrest or warrant where the purpose of doing so is to display the law operating with its full severity. And that is directly from a former Chief Justice of the High Court of Australia. Now, that I think is a damning description and indictment against what we're seeing from Victoria Police right now, where they are choosing to use arrest against people accused of incitement, and I don't believe that charge actually will stand. I'll talk about the legality of the protest and the application of Victorian human rights law in just a moment. But they are accused of inciting people to commit an illegal act. A summons would be just fine. A summons would serve the purpose perfectly well. If they can give them a court date on bailing, then they can give them a summons with a court date on it. Right? That there is no logistical challenge here that stops them from being able to use a summons. I believe it is very clear that they are using arrest in order to create a spectacle, in order to abuse their power and to show the law, to quote the Honourable Murray Gleeson, to show the law operating with its full severity. So I think they are going to get themselves into a lot of trouble because of these arrests.
It's quite clear they're trying to intimidate with it. In Parliament on Tuesday, when we were debating the extension of the emergency powers, the government were really keen to every time someone suggested those powers were dictatorial, they were saying you're all conspiracy theorists. The government wouldn't abuse the power, and then we wake up to see these videos of people being arrested in their houses for posting things on Facebook. It's incredible.
Their defense is, oh, we wouldn't do that, and the answer is you already are.
Yeah.
Now, will the charges of incitement stand up in court? Well, that's a slightly different question. And it depends really on how defense runs the case. If the defense can make it all about whether or not the outlawing of protests was legal in the first place, then I think they're going to run a very good case on the basis that it was a breach of the Charter of Human Rights. I think it's very unlikely that the government would allow a judgment to be handed down if they ran the case like that. I think they would withdraw the charges rather than risk a ruling that basically says that everything they did was illegal. Because if outlawing the protests is illegal, it is going to follow very quickly from there that much of the other contents of that legislation was illegal. Therefore, all of the economic harm, the suffering, the depression, the suicides, the heavy-handed and intimidating police tactics were all unlawful. And you can only imagine the court cases that are going to come out of the other end of that. I was right. I was right at the time. But they just did not listen. A year after that interview, they arrested me for the crime of encouraging people to exercise those human rights to peaceful protest. And they prosecuted me for incitement. Just as I predicted in that interview, they later dropped the charges because they knew they wouldn't stick. Still, that's 2.5 years of my life and thousands of dollars wasted fighting their charges, where they tried to make me a criminal for doing the right thing. They tried to make me a criminal for exercising my human rights while they were violating them. But now they admit that I was right. We were right. There's a chapter in my book titled, "It Sucks to Be Right Early, but That's the Only Time It Matters." And it's all about moments like this. The Australian Human Rights Commission are finally right, but they're right too late. We were right early, and it sucks to be right early. It sucks, believe me, I know. But that's the only time when it matters, because that's the only time when it might actually make a difference. So well done you. Consider this a digital pat on the back. You were right. We were right. How about you send this to everyone else who was right as well? The question is, what now? Now that they've admitted that they abused our human rights. Now, we have the right to get justice. 5 years may have passed, but we have not forgotten, nor have we forgiven. That anger you feel, it's right. You're right to be angry. But justice, well, that's a long-term project. It took 5 years just to get an admission from them that we were right. It'll probably take another 5 before we see any of these human rights abusers being arrested. But rest assured, we won't stop until that happens. In the meantime, sleep easier, knowing that at least the gaslighting is over, because now, finally, 5 years too late, they admit it. We were right.